Welcome and thank you for joining us today for the presentation on setting up trusts. Trusts are a great way to preserve and protect and transferring wealth. Today, we will discuss the benefits to yourself, your spouse, and family, as well as advantages and disadvantages of each type of trust and what they offer. I'm Carolyn Powell. I'm the Business Development Director here at Turcon Seguir & Associates. I'll be your host today and also keeping an eye if anybody has questions or needs throughout. So a couple ways you can engage with us and put in those questions. There should be a toolbar to the right side of your screen. You can put questions in there. Since we have such a big group today, we're going to ask that you put general questions in there. If you have specific questions specific to your situation, your family, I'm going to have you save those for our survey in the end, and then that way Adam can follow up with you directly based on that specific question. But if you have general questions, put them in the question box for us, and we'll try to get them answered. And also there is a handout section, and you'll find a copy of today's presentation in there, and also Adam's bio. I mentioned that we have a post survey. You will receive a survey after the presentation today. Please give us just some feedback if you have any specific questions, if you need to talk to one of our experts, or if there's another topic that you're looking to get some information on. We're starting to plan next year's topics and sessions, so always want to make sure we're providing helpful information to you all. So without further ado, I want to introduce Adam and give him a quick overview. Adam's been with the firm for over 17 years now. He's a CPA and principal in our tax department. He has diverse experience with estates and trust, multi-state businesses, and consulting and compliance for nonprofits. And again, I mentioned his bio is in the handouts. And without further ado, I am going to pass it over to Adam to get us started today.
Hi, everyone. Thank you for being here. And just a quick side note on Carolyn's comments. I've only been here, I think, 13 years, so I'm trying to age me quicker. Should be. But glad to be here to talk about trust, especially today. And it's kind of the hot topic now with everything going on in Congress and legislation. So yeah, let's get into it. Got a lot of material. I'm going to try to move through it quickly, but not too quickly. So let's just go through the topics here. I think the four main things we are going to talk about: when and why are trusts useful and necessary, the elements of the trust, what do some of the terms that you may have heard inside the trust document actually mean, and how do they function. Talk a little bit about the federal New York estate tax. I think that's really what most people equate to trust being used for is, just estate tax and how to save on that transfer tax upon death. But that's what we'll get into. There's so many other uses and reasons why you may want to set one up. And then we will talk about a few specific trusts and how they structured and how they can be used for your planning. So to start, let's just talk about what a trust is, really in its basic form. It's really just an arrangement whereby one person will hold legal title to an asset and manage it for the benefit of another. Again, when most people hear about trusts, they just get the impression that it's for the wealthiest of people and only they need to use them, and that's definitely not the case. I think everyone has issues and complications. Everybody has a family, different varieties of wealth. Families may have complications. Someone might have special needs. There could be issues of maturity and lack of maturity in the family, so on and so forth. So trusts are used for financial and estate planning for a multitude of reasons, not really dependent on just the wealthiest. So due to the flexibility of trust and the amount of planning techniques out there, they're useful in a number of situations. The overall goals in setting up a trust are to protect oneself and a spouse. Could be to provide for spouse and children and also grandchildren. They can be used in addressing a variety of issues related to children, including minority, immaturity, special needs, substance abuse. They can provide for elderly parents. And the most common one that people assume that they can achieve significant estate tax savings through the use of special and sophisticated estate planning techniques. It'll also allow a person to realize their charitable goals if that is important to them, and will provide for protection from creditors, which we will talk about. So again, even if you're not a high net worth individual, it can still provide numerous benefits. One of the items I left off is, the property that's in a trust avoids probate. And probate is, when someone dies, it's the legal process of someone being appointed to manage your estate, either the executor or personal representative, and it's they'll have to go through the process of managing the affairs and distribution of assets out to the intended beneficiaries. So trust will avoid that. Otherwise, if someone dies, even if it's just in a will, it will still have to go through this probate process, which, talk to anybody who's been through it. You're going to go in front of surrogate's court. It can last years, and it could be a quite time-consuming process there. So why are family trusts useful and necessary? So there's some things that you can do with the trust. It will allow the grantor, which you may also have heard the term settlor or trustor, but they basically mean the same things. The person that will be setting up the trust, the intended person that will put money into the trust for a specific reason. One of the reasons, you can make certain your assets pass to the desired person or persons upon your death or just upon effectuating the trust. You just ultimately will have control over the assets, the control of where the assets will go, not necessarily control of the assets. It can protect children and grandchildren until they reach maturity. Just more asset protection here. You can ensure that you protect your children or grandchildren from themselves, for lack of a better term. I find generally, if you have a grantor, he doesn't really want to leave everything to his child or grandchildren who might be late teens, early 20s. It's probably going to be gone, sooner rather than later. So here, you can tie up the assets until an age that you see fit as the grantor, 35, 50, so on and so forth. Just provide a little bit more protection for not only your assets, but to protect the children and grandchildren and whoever the beneficiary are from themselves. It addresses disability and old age. For aging individuals who are slowing down, you may start to need help with your financial affairs, such as paying bills and preserving the wealth you have worked all your life to develop. A trust could fit here as well. You can appoint a trustee to assist in these goals. It can still be your property, but you can be comforted by someone else jumping in as a trustee and helping you along the way with management. Asset protection, one of the most important aspects to a trust. Keeping your property safe from creditors of the trust if it's drafted properly. We'll talk about, I think, asset protection in the next slide. And then lastly, avoid or reduce income, estate, and inheritance taxes. Not as simple as just dumping all your assets in a trust and stopping there, but again, with proper planning, they're a great way to reduce or eliminate estate tax on transferring wealth to lower generations or upon your death. We will get into the lifetime transfer exemption a little bit further. It's always a fluid topic here with proposed legislation and where everything could go, but we'll get into that. So the asset protection, this is really the name of the game when it comes to trust, especially for people who aren't necessarily in an estate tax situation. They don't need to worry about that, and they just want some protection against creditors. If a beneficiary, such as your spouse, child, grandchild, or whomever, come into some financial struggles, the assets in trust can be protected from any of these creditors. If assets are transferred outright or through a will, this will not be the case. All those assets could be up potentially for claims of the estate or the beneficiaries of the estate, the creditors of the beneficiaries of the estate. So many benefits, I think, for the elderly too, who want to keep assets to transfer to their family. The big one is Medicaid eligibility and protection against these elder care creditors. Essentially, an aging person can place assets into a trust and protect them against these creditors, and also potentially qualify them for Medicaid. So Medicaid is a means-based program where they basically want you to spend your money before they step in and help fund for that end of life or the healthcare that will be needed. So placing these assets in a properly designed trust will remove them from your estate. Usually what you'll see is that if someone is getting to the age where they start the process of thinking about potential Medicaid planning or just protection against these creditors, they'll put them in a trust, and they'll usually keep an income benefit from these assets. But the underlying assets, the gift essentially, what's coming out of your estate, will belong to the next generation. So they'll give up control of the assets, but they'll still be able to receive the income from them to pay their bills and live a desired lifestyle as they see fit. So for these Medicaid trusts, the key here is any property that is used to fund a trust or given away will be pulled back for Medicaid purposes, within a 5-year period. So you're gonna have to start, the proper planning now, and really get the clock moving to get past that 5-year look back rule, or potentially any of that trust can be unwound, if they have to have a need to draw on Medicaid then. It can also protect some of your beneficiaries, such as gambling, drug, and alcohol addiction. If you leave everything into a trust for your children, and unfortunately they, either currently have, I guess, one of these issues, or potentially can get one in the future. So it will limit them to how much they can actually pull from the trust to avoid them from depleting all their assets. So just more protection here. Trust can often permit a donor to transfer assets for the benefit of a beneficiary, while also shield some assets from reaching creditors. Spendthrift trust is the term you may hear here, and it will limit your beneficiary's access to assets. Again, more protection. Assets, you can set it up to be released incrementally to the beneficiary based on your wishes. The trustee, who is designated to the trust, will have to comply with the trust instrument as you set up. There can be a spendthrift provision in the trust in this case, and this will also protect the assets available to any creditors that may come from your estate or come from the beneficiaries. Again, if you just want to provide income for your beneficiary, and also want to provide the option of distributions in case they need it, you can add this clause into the trust, and it's really what they call the HEM standard. It'll allow the trustee to make discretionary distributions for health, education, maintenance, and support for the beneficiary of the trust. But it just provides a little bit more protection to not allow that beneficiary to pull assets from the trust anytime they wish. So elements of the trust. So let's talk about kind of what's in a trust, what some of these terms mean, and really the structure of it. First, the grantor, again, can be referred to as a settlor or trustor, but they mean the same thing. This is the person that will start the trust. There will be an agreement between the grantor and the person who will manage the trust. This will be known as the trustee. You can also hear the term fiduciary here. It means the same thing, and they are bound by fiduciary duties. They'll have to act on behalf of the trust document and your interest, not their own. And anyone can be designated as a trustee. You can choose sometimes a professional trustee, an attorney, a CPA, an investment advisor, or family member or friend. So I guess, trustee, that's really an important part of setting up the trust. You'll probably have to run through some consideration and due diligence. First you should decide, can this person handle the duties? How's their honesty? How's their integrity? Do they have an understanding of the beneficiaries and the grantor's intentions? And you also probably, first and foremost, make them aware that you are putting them on as trustee of the trust. Usually they'll know because they should also sign the trust document. But you should also explain to them, what's involved. The last thing you want is someone who got thrown into this role and didn't really understand a lot of the duties that come with it. So just extra due diligence is required here from the grantor to make sure they pick the right trustee. And if it comes to that, you can also pick 2 trustees, 2 or more, and that way you have a team of individuals that can help kind of run the trust and manage it. Okay, so the beneficiary. So this will be who the trust income and principal belongs to. You can have one beneficiary, you can have a number of beneficiaries. Also, the income and the principal of the trust can be split into 2 beneficiaries or more. The trust document can be flexible here, and you can really decide who gets what. The principal of the trust will be the assets used to fund the trust at its creation and any further transfers made during the life of the grantor, pending that the trust allows for future additions to principal. Here you may also hear the word corpus when going through this process, and that's just another word for principal. The income of the trust, so that'll be just like it sounds. Any income the trust earns, such as dividends, interest, rents, business income, passive income, so on and so forth. Any income earned by the trust that will be taxable. Capital gains are the one thing, so realized capital gains are usually not considered part of the income, and they're considered part of the trust principal or corpus. So even though it's taxable income, it's part of the principal and belongs to the principal beneficiary. You can also have income allocated to one person, such as a spouse, and this would be considered an income beneficiary. And then the principal or underlying assets belong to another person, such as a child or a grandchild. And here you might hear the term remainderment beneficiaries. It means the same thing, but that's a common structure where someone will transfer assets in trust for the benefit of, it could also be themselves, but for their spouse, so they can get income from that trust during their lives and, again, live their desired lifestyle, pay their bills. But the underlying assets, upon passing of all those income beneficiaries, will belong to the remainderment, and often it's a child or grandchild. Just some other quick discussion points here. Someone does not have to be alive for you to name them in your trust as a beneficiary. You can create a trust for the benefit of a child. You can add clauses for any future children or grandchildren who you wish to be a desired beneficiary of the trust. It just avoids, these clauses just avoid, you don't have to name each person specifically, and every time someone's born, you don't have to rip out the trust document and start over. Also, if you yourself are young and you want to start a trust and you're not done having children, you can also provide for future children to be included in the trust as well. A life tenant and remainderment. So a life tenant is someone who is alive now and getting a benefit from the trust. While they are alive, they are the beneficiary. They will continue to remain the beneficiary until their passing, at which point the remainderment will jump in and pull into the beneficiary of the trust. This will likely be the trust principal of the trust upon passing of the life tenant. And again, the normal structure is spouse is life tenant. They'll get the income. They'll get the use of that income to support themselves. And upon them passing, life tenancy will then cease, and then the income or the residual principal of the trust will belong to the children as the remainder beneficiary. So an interest in a trust, it could be mandatory or discretionary, just like what it sounds. You can call for mandatory distributions. It would pay income based on what you stipulate in the trust. It could be purely what the trust earns. It could be a set percentage, or it could be discretionable and left up to the trustee. And it's usually, if it's discretionary, it's usually left up to what's called an ascertainable standard. And that's just to really preserve the gift and not have it pull back into your estate for planning purposes. And this standard is, again, usually the HEM standard, which is usually the most common. Anything for health, education, maintenance, and support, as long as it's for one of these, the trustee will be able to make that distribution to the beneficiary. Again, just some further flexibility here. If you create a trust and you put your wife on as an income beneficiary, there could be a point where, things change in her life where she needs more income. She may not be able to get it from just the income distributions. That HEM standard will allow the trustee to step in and provide additional distributions to that beneficiary. The trust can also have current and future interest. So trust may state upon my child or grandchild reaching the age of X, Y, and Z, 30, 40, 50, they'll get that future interest in the trust. The current will start really at the creation of the trust, and the future will be upon that event as the donor or the grantor stipulates. Beneficiary can also be a charitable organization if philanthropy is important to you. It can be a specific beneficiary of the trust, or the trust that can be set up can be a charitable remainder trust, whereby someone that is not a charitable beneficiary will receive the income for life during that trust, such as a spouse, a child. They'll be paid an income stream for their life, and upon them passing, the remaining principal of that trust will be distributed to a charitable organization. I'll talk a little bit about the CRAS and CRUS as they're referred to as a little bit later. So the property. This will be what assets you want to contribute to the trust. You can create the trust while living, such as an inter vivos trust, or it can be created through a will, which is called a testamentary trust. Here, if it's a testamentary trust, it will not be created until that person passes away, and at which point the trust will come in and be funded. It can be funded any way the grantor sees fit. You can fully fund it, or you can fund it throughout the life of the grantor. Just keep in mind so if it's partially funded and it's going to be funded over a stream of years, just keep in mind each transfer will constitute a gift and start to chip away at that lifetime transfer exclusion. The trust can also be revocable or irrevocable. It's just like really what it sounds. If it's a revocable trust, you have full control over the trust. You can change it while you're alive, and upon passing, you can have it become irrevocable. However, if it's a revocable trust, it generally doesn't help you for estate tax purposes, because if you have control, those assets are really to be deemed yours, and it will be part of your estate. So there's other reasons why you might want to set those up, but estate tax savings probably isn't on the forefront there. Okay, so now we'll just get into some of the broad categories of trusts, and there's really three broad ones. First is simple trust, and really in a lot of these it's talks about really how they're taxed and kind of the functions of how the income is distributed. For a simple trust, it requires all income earned during the year to be distributed to the beneficiaries. Separate tax return will be filed. We'll pick up the income, but that trust will not be a tax-paying entity. It will issue, and for anybody out there who's a pass-through business owner, it's going to work the same way. At the end of the year, you're going to get a K-1 showing what the trust earned, listing out your interest, dividends, deductions, so on and so forth. You'll give that to the income beneficiary, and they'll report that on their personal tax returns. However, like we talked about, capital gains may not be considered part of income. So if you sell a ton of stock during the year, that could also turn the trust into a tax-paying entity. Complex trust will allow kind of a blend. It can provide income distributions, but will also allow accumulation of income, either through undistributed income or through just that income being converted to principal. And if that happens, all the income is going to stay at the trust level. Nothing's going to pass out to the beneficiaries, and all the tax will be paid at that trust level. A grantor trust, so that is a trust that's still in control of the owner. It's really more or less a disregarded entity for tax purposes. So it's still, all those assets and the income to it are still in control of the owner. A separate tax return does not have to be filed. I think the trend is that we normally do, and at which point a grantor letter is issued to the person who set up the trust for them to report that income on their tax return. But that generally is not a separate tax-paying entity. So the estate tax, let's talk a little bit about that. So if I can take you back to when President Trump signed the Tax Cuts and Jobs Act, with it came a large increase in the lifetime exclusion. So I think around that time it was near 6 million, and currently it's $12,060,000. And this would be essentially double for a married couple. They'll get their own exclusion. And again, pending any new legislation, which has been kicked around the past few years, it should sunset naturally back to 6.2 million, I believe, by the beginning of 2026. So, and again, this is a use it or lose it deal. So if you don't use any of this transfer over these next few years, and you wait until 2026 to do all your gifting and estate planning, sorry, you're only limited to using 6 million. Otherwise, the rest of it will be a taxable transfer. Annual gift exclusion for 2022 is 16,000, and this is the amount per beneficiary. So if I give $10,000 to 100 different people during the year, I'm covered. So it's not cumulative, it's per beneficiary. You can elect a gift split with your spouse, which will essentially turn it into 32,000 for any one beneficiary. So transfers to spouse is not considered a gift. It's a marital transfer, no gifting there, as well as transfers made directly to a charity or an education institution. So some of the differences between gifting and waiting until you pass to have your assets flow through to your beneficiaries. If you gift now, the basis in those assets get the carryover basis upon the time of the transfer of the grantor. If I were to wait until I pass and just have all those assets flow through and fund a trust at that point, they'll get stepped up to a fair market value. So, I know really if you're in that $10 million, $10 to $20 million of net wealth, I think basis planning almost becomes as big an aspect than just general estate tax planning. I know a lot of people are saying, well, why would I transfer it now? Why don't I just wait till death? The issue there is that $12 million could and likely will go away on you, so you'll be limited. So again, it might just be something to talk through with your professional advisors and the estate team plan about how to make sure that you're necessarily thinking about not only the basis aspects, but estate tax considerations that go with it. So New York's a little bit different. They actually do not have a gift tax. So what that does not mean is that any gifting you do for federal purposes is kind of disregarded and still included in your New York estate, because it will still conform to your federal net estate, which will take into impact kind of what's left in your estate. And if you gifted stuff out of it and it's not part of your gross estate, New York will follow suit there. The only difference is for New York, they have a 3-year clawback rule to avoid any of what they call the deathbed gifts. So any gifts, even if they conform for federal, they'll be pulled back for New York purposes. And the exemption for New York is $6,110,000 for 2022, but it works a little bit different than federal, is in it's not an exemption, it's a cliff tax. So if you have a gross estate of 6.2 million, sorry, the whole 6.2 is going to be taxable. So if you could be in a situation there with 6.5 million of assets, you could be paying $500,000 of New York estate taxes, and someone who comes in at 6 million pays nothing. So we'll talk about some planning techniques a little bit later to kind of mitigate the New York state taxes there. The DC spousal unused exclusion, which is referred to as the DSUE. So this also might require some planning to obtain the maximum benefit here, but basically the first to die spouse may transfer their unused lifetime exclusion to their surviving spouse upon their death. Also referred to as portability, and again, that limit for 2022 is near $12 million. So if I were to pass away and I wanted to leave all my assets to my wife, my gross estate would be 0 because it's a marital transfer. all my assets will go to her. I have no estate. But what can also happen is that $12 million that I had available to me can transfer to her. It gets a little bit more complicated if the spouse remarries. So if the spouse remarries, she will still have my exclusion while that new spouse is alive for her to use for gifting purposes, and if she wants to get stuff out of her estate during that period. But upon the second spouse dying, if she happens to outlive both spouses, then she'll only get the DSU, if any, from the most recent marriage, the last deceased spouse. Again, the problem here is with New York. So New York doesn't have portability. Again, that 6.1 million that we talked about, that's a cliff tax. That's not an exclusion. You can't port for New York. So we'll talk a little bit about really the need for a bypass trust there. So go back up 1 second. So the only other option, or the only other topic I wanted to bring up was the generation skipping tax. You can't port the generation skipping tax either. So that's a use it or lose it deal with the first two die. So and what that is, it's a little outside the scope of this CP or this webinar, but basically it's a second level of estate tax that will be assessed on transfers to a generation more than one lower than you. So what it usually is transfers from grandparents to children or grandchildren or great grandchildren. So that was put in there at the second level of tax to avoid really just these older people setting up trusts saying, you know what, I don't want my kids to have an estate tax problem. I'll give it right to my grandkids. You can do that, but you have to use your GST. And it's a little misleading because you don't get $12 million to transfer for both your children using your regular lifetime exclusion and another to your children or to your grandchildren under the GST. So any transfer that already is a gift, which means it's going to use that lifetime exclusion, will count, or any GST transfer will count towards that. It's just a matter of whether you allocate it to that or not. Here again, you'll see a dynasty trust, which we'll talk about a little bit later, as the most often GST allocated trust. So a living trust. We'll get into a few trusts now. I think I got 20. Not long. So a living trust, so that's it's a grantor trust. It's going to be a trust created during the life of the grantor. It's going to provide control over his assets. It's funded while they're alive. It's fully revocable. They can change the trust, change the trustee, whatever they want. They can revoke the trust if they so choose. Upon passing, this trust will become irrevocable and the property will be distributed in accordance with the trust agreement. Again, it's a grantor trust, so it's disregarded for tax purposes. So some of the advantages here, it's not necessarily an estate tax savings vehicle, but it will provide confidentiality. If everything was left via a will that sometimes could become public knowledge through estate surrogates court proceedings and so on and so forth. And again, it will allow you to eliminate probate upon passing. So since these assets are titled to the trust, no need to go through probate. We know where they belong. Similar to that, it will also eliminate a lot of the time-consuming and expense of going through estate administration proceedings. To provide protection in case of incapacity and disability. That happens, the trustee can step up and continue to handle the assets in the trust and the financial affairs. It also provides flexibility. Again, they can change it while they're alive, so it's not irrevocable. You're not separating yourself from the assets, so that's a nice benefit there. So some of the disadvantages are, I guess, one of the one that's a big pain I hear is that, once assets are transferred into the trust, you have to go through the process of then retitling every asset that was in your name, and you got to retitle it to the trust. Also, it doesn't provide protection against the grantor's creditors here, the same way that other trusts might. Again, it's part of your estate. It's revocable. It's in your control. They're up for free grab if you have a creditor come up. And then really generally no income or state or gift tax savings here. But that could be okay for some people. Some people who don't have an estate tax problem and they just want some peace of mind and to put these assets in a vehicle that's under proper management and provides some guidance on where they go upon their death, that could be an option here. So the bypass trust, also called a credit shelter trust or an A and B trust agreement, they're usually referred to. It means the same thing. So this is a trust where you'll set up and you will use the exclusion of the first to die spouse. Since most states don't have portability, I think there's only 2 that do. This really should be a necessary part of your estate plan, especially if you're in that Buffalo high net worth wealth, I call it, 20 million assets or less. So this will generally involve transferring the assets to a trust up to your exclusion amounts of that 12 million currently, with the underlying assets or the principal of the trust being for the benefit of your children or grandchildren. And the trust will usually provide income to your spouse and potential for those HEMS distribution, as we talked about, for her life. It's a great way to remove assets out of your estate, but also, look, I still want my spouse to be taken care of. I still want her to, get the income from the trust and live a desired lifestyle. This is a good option there. And since New York again does not have portability, you can't move that unused exclusion to your spouse. It's really a go-to for New York planning for all our residents here. So how this will work. So if I pass away, what I would do, if let's say I was worth $20 million, I would, instead of leaving it all to my wife and leaving her with 20 million of estate assets and throwing my exemption of 12 million her way to use, I would say, look, I'll take 12 million of those assets now, put it in trust for the benefit with wealth and income benefits for my wife, and I'll have my children be the remainderment beneficiaries. So effectively, I'll use my exemption, and then my wife's estate will probably be somewhere around 8 million. So she'll get all the other assets through a marital transfer. I still won't have any estate tax because all the other assets are a marital deduction. So that will whittle my estate down to a 0 taxable estate. And then when she passes, she will only have to have about $8 million let's assume she passed shortly after me, there's no appreciation. She'll only have about $8 million of estate assets, and she'll be able to use her exclusion to wash that away. So one of the benefits here is if a decedent, if this trust is set up to effectuate on death and the decedent happens to pass away fairly early at 2000, say he's 60, 70 years old, you set up that trust now, so those assets are out of his estate. So say your spouse doesn't die until she's in her 90s, who knows, that $12 million of assets in the estate could have appreciated quite substantially, maybe up to 20, 25 million, but it doesn't matter. All that appreciation is out of your estate. So you can lock in really the value then and just remove that from being your wife's problem and her passing. So again, just here's some of the kind of benefits of portability. Any future appreciation of assets out of your estate, as opposed to just using a marital transfer. You'll lock in that transfer on death, and the rest of it can go to your kids and escape taxation from estate transfer taxation from your spouse or their mother. GST. Since you can't port GST, you can use that election on the trust and protect it as a GST trust. So that'll just allow, kind of further flexibility in the future for your children to use, as they can potentially remove that from their estate as well if it has the necessary GST allocations. And then lastly, the lifetime exclusion is going to go away. So if you don't use it, you lose it. So it might make sense to set up one of these trusts while you're living and not necessarily wait till death to get these assets out of your estate, lock in that exclusion. Again, they can't claw it back on you. So if you use the 12 million, good on you. So it's probably not going to be that high again from what I'm seeing through potential legislation. So let's go through kind of an overly simplified example, as it relates to New York for the bypass trust. Let's assume that, me and my wife, we're worth about $10 million. I pass away. In this example, I'm not going to set up a bypass trust. Instead, I'm going to say, you know what, let's just, I'll send everything to my spouse via a spousal transfer, my taxable estate 0. I will also send her my unused exemption, the DSUE, for use when she ultimately passes. And again, to keep things simple, I use the same kind of the second kind of example down there. Let's assume she dies shortly after me, and no appreciation in the assets, no change in the deceased spouse, unused exclusion, it'll be the same. So when she passes, for federal purposes, she's fine. Gross estates are 10, and she has nearly 24 million of exclusion. However, for New York, you're in a little bit of an issue there. Again, they don't have portability, so that unused exclusion does not go for New York. She is left with a $10 million estate for New York, all of which is taxable because that $6.1 million kind of exemption down there. It's not really an exemption. It's not a credit. It's once you're over that amount, the entire estate becomes taxable. You're looking at roughly a New York estate tax of $1 million. But, again, living in the Buffalo, the high net worth market, I call it, the 10 to 20, it's really a sweet spot to do some good New York estate planning. So in this example, let's assume a bypass trust was set up. So I die, I have $10 million of assets. I'm going to say, all right, well, I'll give nearly $4 million to my spouse via a transfer. That'll knock my estate down to, and this is really just for New York estate planning, that'll knock my estate down to $6.1 million. And at that point, I will set up a trust. I'll put that $6 million in a trust for the benefit of my wife as an income beneficiary, but my children will be the underlying remainderment beneficiaries. So it's out of my wife's estate. They're the ultimate, beneficiary, the principal. So what that's going to do is that funds is now out of my estate. So when my wife passes, I'm still all set for federal. Even her exclusion would cover the loan, but she'll also get the remaining nearly $6 million of what I didn't use. But for New York, those assets are out of your estate. And as you can see, instead of using the 10 there, we're going to use the just under $4 million. And here we're under the New York exemption, 0 tax. So even if you're around that $10 million mark, I think setting up these bypass trusts for New York purposes is, it should be a slam dunk. And it might make sense to do that, now over the next few years, even though the New York exemption is lower than the federal kind of exclusion, just lock that in, get that done, and then you can avoid really a New York estate tax problem altogether. So here are a couple trusts to set up for a surviving spouse. These trusts will afford you the marital deduction. It's not necessarily a huge estate tax savings part for husband and wife together, as those assets will still probably generally be included in the second to die spouse. There's a couple things you can do here. One is an estate trust. I'm going to move through it quickly, but that basically provides the assets to your wife and provides for no income distributions. Those aren't used a ton anymore because it's rather cold. You're going to give the assets to your wife, but not let her use any of the, not let her get any of the income. The second is a powers of appointment trust, and that will provide for no requirement to distribute income, but she'll have some powers where she'll be able to get distributions if she needs to based on those HEMS standards. So the spouse won't have control over the property at her death, as this will, well, really the main thing here is that it's going to transfer to your spouse, but upon her death, I'm sorry, I mixed that up. So you're going to give her the powers of appointment to control the trust upon her death. So upon you passing, the funds are going to go to her, and then she'll have power to what to do with it upon her death. So the next one is the Q-tip. So this kind of bridges a gap between those two. It allows you to provide a marital deduction via transfer of assets to your wife. those assets are going to be held in a trust that's going to be an estate deduction for you because it's a marital transfer. It can provide her income for her life, but the big thing here at the Q-tip is upon your spouse's death, the original grantor, the first to die, their estate plan will then come rushing through and provide kind of the guidance on how to distribute those assets. Here you see a lot of this with, I guess if you have a marriage with blended families, kids from multiple marriages, and then each of them want protection. You can set up a trust saying, look, I want my assets to go to my wife, but upon my wife's passing, ultimately I want, either all of them or some of them to get to my kids, because life gets complicated. When you got a lot of these blended families, and upon someone dying, who knows, they could have a falling out with the kids of the original trustor. So this will just provide some protection to say, you know what, these assets go to my wife, it can be hers, but upon her passing, I decide where I want those assets to go. So the SLAT, the Spousal Lifetime Access Trust, that has been very popular really this year as well too. And what that's doing is that let's assume spouse A will create a trust for spouse B, and will usually fund it with as many assets up to the $12 million exemption. The marital deduction is not elected here, as the goal is to really use that exclusion. Let's lock in those high rates. They're going to scale back on us. Let's get some assets out of our estate now before they do. And generally, it will provide income to spouse B for their life, with the underlying assets going to the children or grandchildren. Since spouse B doesn't technically own the trust assets, as this one is kind of created, they are not included in spouse B's estate, so those assets are out of both husband and wife's estate. And then it will use spouse A's lifetime unified credit at the time of transfer. The only downside here is that spouse A is essentially giving up control of the assets. So if there's a possibility of divorce and you were saying, look, I wanted to do this SLAT with my wife, I'll put all our assets in there. It'll provide income to us for our life. If you get divorced, I'm sorry, she has no obligation to share that income with you. So you could be in a little bit of a problem here. So really you want to make sure that the longevity of the marriage is intact. It's not the end of the world. You can add some clauses in there to protect the spouse in the event of a divorce, but it could unwind a lot of planning that has already been done. One of the workarounds is that you can both create a SLAT for each other. Spouse A puts some assets in for the benefit of spouse B. Spouse B does the same for spouse A. The only difference here is that they cannot be reciprocal trusts, or else the IRS will just void the gift, and that means that they can't be the same trust. Usually an attorney will have different powers in there, such as different trustees, different terms, different powers of appointment to get around this clause, but that is a common approach too. I'm going to move pretty quickly now. The Irrevocable Life Insurance Trust, another popular trust, and that's basically a trust that will hold and also be the beneficiary of an insurance policy. The policy proceeds will not be included in the estate upon the death of the grantor. If you're going to transfer a current policy into the trust, it needs to be in there for 3 years in order for it to satisfy the look-back period. If you pass away within these 3 years, that proceeds is probably going to be includable in your estate. If it's a new policy purchased out of the trust, I think you're good. There's no look-back period. But any future monthly or annual premiums are going to be a taxable gift to the trust every year, and will need to be reported on the gift tax return, and we'll use your lifetime exclusion. We'll see how much longer this one's available for. I think this is really item number 1 for legislation to get rid of. I think the last one I saw in September of last year, they were going to get rid of this altogether, but would grandfather any trust that had a premium policy. They had a policy that was already fully funded, which, for some of these big policies is usually not the case. A dynasty trust. So that one's really a trust you want to set up if, say, look, I don't want anybody to have control of my assets. I just want to pass down my wealth through multiple generations, grandkids, great grandkids, so on and so forth. It will provide only life estate in the trust property, which means that they will get income for life, but they can't really touch the assets. So here, these are what you see a lot of the GST trust, the Generation Skipping Tax Trust, or Generation Skipping Trust. The original grantor will allocate their GST exemption to this, and will be able to move through generation without being included in any of those children's estates. Again, I can see this one going too with any proposed legislation. I think some politicians have I think, kind of consider this almost an abusive trust, really, and outside the scope of what they were intended for. So I wouldn't be surprised if there was future legislation removing this one as well. So quickly, I'll go through what's called split interest trust. And if you're a person who, philanthropy is very near and dear to your heart, you have some options here too. So we have what's called a CRAT and a CRUT, a charitable remainder annuity trust and a charitable remainder unit trust. So basically, you will fund a trust with assets of your choice, with the income beneficiary normally being a spouse or a children. So during the life of your children or a spouse, they will get the income that the trust earns. Upon their passing, the principal will all go to the charitable organization as a remainder and beneficiary. So what this does is that this will give you a estate tax deduction for the actuarial value of the remainder interest in the CRAT or the CRUT based on the IRS tables. So it allows you to get a charitable deduction while also taking care of, some income needs for your spouse and your children as you see fit. So the only difference between the CRAT and the CRUT is that the remainder annuity trust, it's a fixed annuity. So you're going to decide, I want $5,000 a month. I want, any fixed income, any fixed payment to the beneficiary. And the charitable remainder unit trust, that is normally a percentage that is redetermined every year based on the fair market value of the assets. Charitable lead trusts are similar, except they work the other way, and that the income beneficiary of the trust is the charity, and upon a set term of years, based on what you decide, 10, 20, 30, their interest will cease, and then the underlying assets will pass to your children. You will get a charitable deduction, a state tax charitable deduction for this as well, based on the actuarial values of the present value of those income streams. So these aren't, I think, as common as the prior two, but they are out there. And these can be flexible between grantor trusts and non-grantor trusts. So if it is set up as a grantor trust, keep in mind that's a disregarded entity. You're in control of the trust. You're going to report the income. You're going to report the income and pay the tax. Here, the grantor will get an immediate itemized deduction for the present value of that charitable deduction. But the issue is that the income is going to flow to the income is going to be reportable on the grantor's trust return, but the tax is going to pay there, but the income is not actually going to go from the grantor trust to the grantor. It's going to go to the charity. So you're going to get into a situation where you're picking up income on money you're not receiving, so that could potentially cause some cash flow problems to the grantor. So just be aware there. And then the last trust we'll quickly talk about is the qualified personal residence trust. And here's a trust where you're going to place a property into a trust. Doesn't have to be your primary residence, can be a personal, can be a vacation home, so on and so forth. And it's really used to freeze the value of the home. You're going to make the transfer, put the property into the trust. You're going to get the value of the transfer will be the present value of the remainder interest in the trust, as determined again by those IRS tables. And then during the life of the trust, the grantor will be able to continue to stay in the trust, use it, enjoy it for the number of terms or number of years that they choose for the term. And then upon the grantor outliving the trust, you're good. The residence is out of your estate. All the appreciation is avoided. But at this time, though, the grantor needs to start paying fair market value rent, likely to his children, whom he designated as the remainderment beneficiaries of these trusts. So keep that in mind too. And again, the difference in terms, if you have a 30-year term, the present value and the actual gift will be quite low. But again, the issue is it's great having that low value, but if you don't outlive the term, all this is undone. So that whole value is tough. Trust is pretty much going to be unwound, and then the asset's going to be in your estate based at fair market values at your time of death. So it's kind of a mixed bag there. You can choose a higher term, get a lower rate at time of transfer, but again, you have to outlive it. So there's some special consideration might be needed there. Okay, went a little long, but I figured that would have been the case. But
There was a lot of good information in there, so gave a lot for people to think about. We do have actually a couple minutes for questions. There was a couple that were submitted, so hopefully you'll be able to answer them. I'll kind of just read them, and hopefully they're general enough. If not, we'll get back to these people individually. So David has a question. First generation formed irrevocable trust. Subsequent grandchildren born, but told no beneficiaries can be added.
I might have misspoke. Even if it's an irrevocable trust, you can add the necessary clauses to include unborn children or other, I guess, kind of children of your children that would arise during that time.
Okay, so David, hopefully we answered that question for you. If not, let us know if you have additional questions on that. Christopher has a question here. What trusts are recommended to protect assets against nursing homes for surviving spouses? If one went into a home and other assets were required to be spent down?
I mean, any one of those trusts, the bypass trust, a SLAD, any trust where, you know, the goal is to really get the assets out of your estate, so have your children be the remainderment beneficiary, but also provide you income for your life would be a candidate there. There's a number of trusts that allow you to do this pretty simply to get past the Medicaid hurdle there, and I can send you a few outside the presentation.
Great, Christopher, we'll get back to you on some more of that. Ron has a question. Do you have experience in trusts for non-residents?
Limited, not setting them up, but it's kind of tricky for tax purposes.
It looks like he's from Canada.
Yeah. Yep, those have been the ones that we've historically dealt with. I know we have one of our foreign experts here, Dave Lever, principal in our tax department, does a lot of work with that as well. So yes, we can probably get you an answer if you have a certain situation.
Great, sounds like that could be a group call follow-up. Judith has something on here. What about trusts set up by single divorced adults?
Yeah, I mean, it's what are you trying to do there, I guess, is the kind of goal. I mean, you can, just because you're not married doesn't mean you can't have your ex-spouse be on there as an income beneficiary. You can really choose the beneficiaries as you see fit, so there's no really requirement to be married. You're going to lose you're not going to get that the portability there, so that might be some planning required. But yeah, I'd be happy to touch base with you after to get what you're asking there. But yeah, there's no requirement for your beneficiaries to be even related. So.
Great. Thank you. Those are the questions we have for now. If you submit any, we will still get back to you on those. Like I mentioned to you, there will be a post-webinar survey that'll be coming out. If you have additional questions, you can put it in there. If you want to talk to Adam on this topic or one of our other experts on just a general tax question or a general accounting question, that will be available in the survey. Just let us know. Also give us feedback on this webinar and or other topics you would like to see for next year that you have questions on.
Yeah, maybe permanent, even do another one just on specific types of trust. Spend more time to devote to that. So maybe something we can think about.
Great. Yeah, there was a big audience today, so I'm sure we can dive in deeper into some other topics.
Yeah.
Judith had a follow-up. Is there any tax advantage for singles leaving money to their children?
I mean, if your estate's in a situation where it's taxable, I mean, yeah, I mean, again, it's really what you want the trust for. If it's just protection against creditors, if it's knowing that if you do pass away, the assets are going to flow in accordance with your wishes in the guide in the trust document, then yeah, it's definitely a fit. I think trusts are really for everyone.
Lisa's got one just come in. A lot of questions today. For the lifetime transfer exclusion, can you transfer assets now and then more years down the road?
Yes. But say if you put in 8 million now, while the exclusion's 12 million and then it sunsets at 2026 back down to 6, you're out of luck. They're not going to claw back that 2 million, but you're also not going to be able to use the amount you left on the table, so to speak.
Okay, a lot of good questions here.
So I think back to Judith's question. So I think if I can understand what she's getting at, the option there would probably be an intentionally defective grantor trust. So that'll allow you to get the assets out of your estate, provide you the protection, but then those assets will provide you, the grantor, some income there if it's needed. But again, yeah, I'd be happy to talk to Judith offline here to see if I can help at all. So Lisa's question, could you transfer 4 million now and 2 million later? Yes. Yep. You can transfer, while you have the exclusion, you can use it, but again, it's use it or lose it. So, but yeah, it's not uncommon for people to make yearly transfers, and a lot you see is small business owners, they'll slowly gift away their interest in their closely held company really year by year. But again, you got to use it or lose it. So, and we got until 2025, if not taken away sooner, which is a very real possibility.
Okay. Well, we are going to wrap up for today. We are just over a couple minutes. I want to wrap up. Next month's topic will be Economic Nexus on October 11th. If you're selling into multiple states and have sales reps or employees in other states, you will want to join us next month. So thank you for joining us today, and we will follow up on any questions people have and continue this conversation. Have a great afternoon, everyone. Thank you.